I guess I'm about ready. Everybody else ready to go? Yes, I'm glad you're here today. I'm going to talk about some things you might be able to jump in on and help with. Just starting out, what I'm going to go over today is something that is not Northwest MLS contract forms. There's a difference between having a contract, which is forms that we put together to assemble to create a contract between a buyer and a seller, versus statutes in Washington State law. And Washington State law, which comes out of the Dome building in Olympia, come out with all kinds of things that interact with our industry, the things that we need to comply with. But compliance with these things is about compliance with state law, not about compliance of a contract. And those two things shouldn't be intermixed. They should be kept separate. The two forms I'm going to talk about, one's 22K, which has to do with utilities. The other one is Form 17, which has to do with seller disclosure. And because there's statutes, even when there's non-compliance with those, they actually are triggering compliance, and then any kind of penalty that is associated to that comes out of Washington state law. So, I mean, things like fraud or things like any kind of administrative abuse, there's different codes that have been reflected in these things that are for how things are adjudicated if someone breaks the rules. And so I wanted to start off with, this is a couple of slides I got from Annie Fitzsimmons when I went to a contracts class with her. I like starting out with this because it feeds right into these two forms. One of them is a purchase and sale agreement is a contract between a buyer and a seller, documents not creating contract terms and not between a buyer and seller do not belong in a purchase agreement. They don't belong in the contract set of documents. Potential for confusion, inconsistency, and ambiguity exist. So basically, this is, again, right off Annie's slide, do not attach a Form 17, a 41D, notice of compliance, properties, MLS printouts, any of these forms. They're not contract forms. Extraneous documents. So what happens when, let's say you're a listing broker and you get an offer, and the offer comes in from the other broker, and they got FERPA stuffed in there, and they got Form 17 stuffed in there, and they got the fraud alert stuck in there. And the next thing you know, they put a title report in there, and next thing you know, you have a 100-page offer. And what happens if the seller says, "Want to accept the offer?" It's a good offer.
So that's a question.
Yeah, it's a question. It's right.
That's a question.
What should the buyer broker do? What do you do if you were a listing broker and received a buyer offer with all of this attached, and your seller wants to accept the buyer's offer without countering?
You separate the documents and you have them sign the offer, and then you send it back in the same email, but two separate PDFs.
Just like that, absolutely. And it's just that simple. And the place you do that, Northwest MLS and Transaction Desk, when you have an area for forms, an area for documents, you just upload that into documents. There's a little stoplight, you hit that, and it drops down. There's a thing that says slice. If you click on slice, it opens up that document, and you can delete and remove any of the forms you don't want in there, and then save it. And now you have a pure contract document.
Say that again for me, because I looked all over for that the other day. It's under documents.
I can show it to you.
Oh, he showed it to me too. Okay, I just need one more refresher of exactly where that is.
Another way is when a Athenasign sends that thing that says, see the complete document, go here. Just scroll down the page, and then they're individually, you can download them individually into your file, and then you don't have to separate them. But if you do, then what he'll show you how to do that in the transaction desk.
Yeah,
Is that where you were?
I was in the transaction desk, and yeah, I couldn't find that magic little stoplight he's talking about.
So
I haven't seen this stop.
So this one here is Tom's docs to sign. This is something I use for utility, for just splicing things. It's just a made up transaction. It's handy for me to do these kind of things. So this is what I'm speaking of, is when you're in a transaction, you have your choices over here for menu. Forms is where your Northwest MLS forms are, but documents is what I'm referring to. If I come here, I can turn around and I can upload and add a new document. Let's see if I have one around here. I'll put one in there. Just drop it in here and then upload it. I don't know if I have one here. Here's this one manual. Okay, so I do. I have one in here. So what I wanted to do, if I wanted to modify this one and separate, I just come here. This is a stoplight. That's what I refer to as a stoplight. If I click on that and I scroll down, I will find slice and markup. If I hit slice and markup, it'll turn around and I'll say, okay, I want to slice. And so now that it comes in here, I can now delete a page and separate them out and say both of them or whatever. But the thing is, just play around, experiment with it, and it'll run, and you'll get it. Okay.
So if you do have a purchase and sale agreement that has like 35 pages, because it has all that extra junk, just be aware that it's very small individual page. So it's really, but it's a wonderful tool.
Yeah, it's a great tool. You will also find sometimes you'll download a Northwest MLS document and you want to turn around and you want to combine forms, and because it's locked up, it will not let you do that. That's how you get around it.
Right in there.
I load it up in there, I turn around, I can combine, make any combination I want, and then I just download it. It's done.
So
Okay.
can I ask a question
Yeah.
that I should already know?
Yeah.
On the previous screen, it included FERPTA on there. Is FERPTA not supposed to be included in a purchase and sale when it's addressed in the purchase and sale?
It's not a contract document. There's a FERPTA form that's made to go in there, but the actual deliverable is the signed form by the client. And that's not supposed to be in the contract.
Okay. So even though it's addressed in the first page of the purchase and sale, it does not need to be included in the full offer.
Not in the full offer. No.
Okay.
Because that's what you're doing, is we're starting to define the difference between contract documents versus deliverables. A contract document may have requirements that it's calling out to be performed. And those things, as they're performed, need to be exchanged between the brokers and the buyer and seller as goes into the transaction file for conforming to the contract deliverables.
And sent to escrow.
And then send it to escrow so that all the transaction file is complete. And that's the difference between a deliverable versus the actual contract that calls out what's to be done. So one's saying this needs to be done, and say, okay, I did it, this is it.
Okay.
Okay.
Cool. Thank you.
All right, you bet. Okay, but I want to start out with, that's one of the things that Annie always talks about is, if we're going to be acting in the capacity of an attorney when we select forms and fill them out, then we need to raise the bar on how we look at our services, that we really are acting as a lawyer. As soon as we pick that form, we should be held to a standard. And that's what this whole class is about, is the industry and what you see from other brokers. And we review contracts every day. It's amazing to us, the different things we see. And so the thing about this is trying to act with confidence when you talk to other brokers and then to your clients. And that's what this is about, is having the confidence to know that you're correct and doing the proper protocol. Now you have a problem of educating the other broker and try not to insult them and try and get them on board so that they clean up the contract. And so that's part of what we're going to be trying to do here today. So starting out with this, with 22K, let me see if I can find it. What I wanted to start out with, let's see, is this it? Let's start off by talking about 22K and its origin and where this whole thing came from. This is really a legislative movement to make sure that when there's a transaction sale between a buyer and a seller, that the seller makes sure that everything that needs to be paid before the transaction goes to the buyer is paid. And the escrow officer is put in charge of facilitating this. And it's called out in statute. And so the records of account, this is every licensed escrow agent shall keep adequate records determined by the rules of by directory of transactions. They have to keep these records for 6 years, and it's called out under RCW 1844. And so let me just pull up the next one. In doing this, there's a lien and unrecorded utility charges. The seller of real property is responsible for satisfying a lien, closing agent's duties and liabilities and fees. These are defined by RCW. This is Washington state law. And as it calls out, these charges, as they define them, are all the things that are specified in RCW's 3521, 35. I've looked up all of these. I'm not going to bore you with them. I'm trying to make a point that this is where this is coming from. This is not from Northwest MLS. This is coming from the legislature. And so as we come down through here, there are things spelled out in this law that had to do with the seller's duties to inform the closing agent. So there is a legal responsibility for that seller to give this to the escrow officer so that they can do their job, because they're made responsible for making all of these settlements. Now, the only way that you can get out of doing that is if you waive it. And let's say you have a piece of property that has no utilities on it, and it's just 10 acres of dirt. Well, you don't need to have utility, nobody's ever installed one, so you can waive it. Okay. But in the case of where you have a residence, it's recommended every offer have this form in it. So this is something that I'm going to attach to the notes, because I always like to have all of us start by grounding, knowing what the law is and where it came from, and then see how Northwest MLS has handled this in their instructions. Okay. So let me move to the instructions. So this is 22K's manual that you will get out of the Northwest MLS. And as it comes down through here, again, I have this highlighted and I'll send it out with the notes, is that from the origins of 6080 RCW, the seller in a purchase and sale agreement transaction must include a purchase and sale agreement and a written request to the closing agent to disperse closing funds necessary to satisfy unpaid utility charges affecting the property, unless the buyer and seller agree in writing to waive the closing agent's services. Okay, pretty clear up to there. The statute applies to all real property sales transactions, including commercial property. The thing to note about this, and it's the same thing with the Form 17, is that if you have a FSBO, you have people that are just exchanging property between each other, they are outside the law if they do not do this. And that's one of the things about a real estate broker. You're always talking to somebody that likes to do their own transaction and thinks they know a whole lot of things. And you kind of say, you know, there's some things I'm trying to protect you to stay within the legal side of things, is you have to have this form and you need to fill this out and give it to your escrow officer. This transaction is being done by you. Even if either of you have a real estate broker, you better do this. Okay. And this one here is his calling out Form 25. This is where you can waive it, is on paragraph 15. Well, the only problem with that is that just within a month ago, they had an upgrade to the form. And so now it's actually services of the closing agent, payment, utilities. If you're going to waive it, you can check this box. And that's on now item 12. And so all I try to do is clean up on this. This is now paragraph 12, item 12. Okay. The other things in this instruction as it comes down, as the seller is required to provide the names and addresses of utility providers within 5 days of mutual acceptance. So this is something that what you're going to find here later on is that the listing broker really should be gathering all this information at the time they get all the other information from the seller and just fill out the form at the same time and have it completed. But seller offers may not want to accept such an offer without having immediate access to those names and addresses. The thing that is really sloppy that you've noticed is that this form is very rarely filled out completely. And it's just saying PUD or things, and then they just turn it in and send it to Vanessa. If you do that and that doesn't have a completed form on that, in essence, you really could take the job of the escrow officer and then remove their responsibility. So if they miss somebody, they miss a payment, and that's because there was no phone number, no address, and wasn't filled out incorrectly, then they don't have a legal obligation that they can be held to for the standard of doing this service, which is very articulated by law, that unless they get complete information, they're off the hook.
Can I just say, Tom, that a lot of times when and I'm not in escrow right at the moment, but at the time, which was recently, that if there was not, this was not addressed in the purchase and sale agreement, I couldn't get any information, then the escrow officer is incumbent to actually provide instructions saying that it should be held outside of escrow between buyers and sellers themselves. So you can always look for that language too in supplement to the escrow instructions.
But basically, you guys figure it out then, because you didn't give us the
Well,
information.
we're protecting our ass.
Yeah.
So if we know that we need all these elements, like Tom's saying, these are all the elements you have. We know we need all these elements. We need these things in order to clear title. So if that information is missing and we can't obtain it, we're going to exclude ourselves from being responsible for that. So where is it gonna, the responsibility gonna go if we don't have it?
Yeah.
They're gonna look to the agent.
And this creates adds to a bigger problem that I run across in researching this, is that clarity is when you use the word, you shall do this. But then you start saying, well, you may do this. Well, may is I have a nice idea. No, I may do it, may not. So is a may something I can contractually be held to? It's wishy-washy. It's not good contract language. It's not good legislative language, but the legislature has done it. They have really messed this whole thing up because they say further, the buyer and seller authorize the listing broker and buyer broker to fill in the required information so that it will become part of the agreement. So the escrow officer is responsible for doing this and making sure the bills are paid. And the form is responsible of the seller shall fill this out within 5 days of mutual, that, the brokers may fill it out or may not fill it out. So does that mean the seller's off the hook because we have May people that could fill it out also? I don't know. It's a mess. This is really not well done. For me, it's a red flag. And the way to clean that up is because we can take the fiduciary responsibility of representing our client. And if it needs to be filled out correctly, then we can make sure that it's done correctly and protect our client.
I would also.
And I don't care if on the seller side or the buyer side. Because if it's a buyer, I don't want them to get stuck 3 months from now from a bill that wasn't paid and then call me and then it's my fault. And they go, no, it's the escrow officer's fault. No, we may have done it because it may have been the listing broker's fault because they didn't fill it. Who filled it out? And this is not a good situation. That's where as a broker with fiduciary responsibility for a client, take control of that, take ownership of it, make sure it's filled out correctly. And it really should be done at the time of listing when you're sitting down with the client and putting the listing together. That's the best time to have the knowledge and get it right there. Then it's done.
This is another example of reviewing your settlement statements prior to closing as well. I mean, escrow people get busy. They might have an assistant filling in their information. It may not be down there. So if you notice it's not on there, then you can address it.
And so I want to point out right in here in the instructions that it says, no, it is a good business practice for listing brokers to obtain this information from the seller at the time of blah, blah, blah. Okay. So last but not least, I wanted to just show this form.
And with the revisions on July 11, then the Department of Licensing is now looking for if a utility is identified that it should or it shall have the address, city, and zip. Now, there are other information that you can put in there, like a website, or to me, I don't understand. They have a fax number. Why in the world don't they have a phone number? To me, that seems more important. But compliance with command, if it isn't filled in, the utility name, address, city, state, and zip, it'll be returned. And
Which actually is a good thing because it makes sure that the buyer is protected by having it filled out completely. But there's habits that are lazy that it's hard to retrain people that have been a broker for 10 years and they've never done it that way before. Now you're making them do it and they kind of get ruffle feathers. It's not about that though. It's about raising the bar and really taking care of our client. We're responsible to look out after them. They don't know this stuff. We do. So we need to step up. This is where I get annoyed. It's actually in the form. Is request the closing agent to administer the disbursement of the closing funds necessary to satisfy unpaid utility charges, if any, affecting the property, the names, addresses of all utilities providing service to this property and having lien rights are as follows. So boom, right out of right out of the legislature that I looked at first document, and then we come to here, if the above information has not been filled in at the time of mutual acceptance of this agreement, then one, within 5 days of mutual acceptance of this agreement, seller shall provide the listing broker and buyer broker with the names and addresses of all utilities provided within liens rights affecting the property. And if they stopped right there, this would have been a very clear directive, but they didn't. Buyer and seller authorize listing broker or buyer broker to insert into this addendum the names and addresses of the utility providers identified by the seller. So there we go. Now we have something perfectly clear, shall do, messed up with a couple of, oh, we're going to authorize the brokers to do this if they decide to. So who's responsible now? So I really don't like what they've done to us. And that's why I really thought it's important to point it out, to talk about it, because other brokers are not on the same page as what we're talking about right now. Nothing in this addendum shall be construed to diminish or alter the seller's obligation to pay all utility charges, including unbilled charges. Buyer understands that the listing broker and buyer broker are not responsible for or to ensure payment of seller's utility charges. So that's how they've made this one-page form. I wanted to go backwards from the origin of it, from legislature, start looking at our instructions in Northwest MLS, and then look at the actual form. For me, it's protocol. If it's not filled out by the seller broker, is take the initiative and see if we can't figure it out and have it filled out so that escrow has the, and then they have clear responsibility for the escrow officer to have what they need to make sure the buyer's protected. End of story. That's it. Okay. Any questions or comments? It's a sneaky little form.
Well, sellers don't even know all of their utility information.
It's true.
Say it again, Vanessa.
A lot of, believe it or not, a lot of sellers don't know all of their utility information. That's why it's also good to make sure you're looking at the title report to get some clues too.
Yeah, see that what those liens are. So now I'm going to move off into another start with the state law of the legislature. This is right out of the RCW 640615, unimproved residential real property. And there's both of them in here. The other one is a segment. This is for improved residential. And these two documents are very similar. But as you come down through here, it's interesting from the original RCW actually has all of these questions and yes and no and do nots, and now they've added on to them and changed them. But when they wrote the law, the legislature, they wrote all these questions out. I mean, this is specified. There is no way of altering or changing these words unless you go through another bill and change the statutes. So this stuff is locked in. Now, as I come back through the RCWs, for your protection, you must date and sign each of these pages. It tells about the seller's responsibility to fill this thing out completely. And then it's notice to the buyers. If you'll look at this is actually coming right off of the Form 17 that since that's the way to state law, that's where he transferred it right into this Form 17 form. And this is where it came from. Okay. And by the way, to rescind, that's Form 98. We'll be talking about that more. Another thing I wanted to talk about is delivery. Delivery is specified by law. A lot of brokers are taking Form 17s and they put them up in associated documents in their listing. And then they turn around and you ask them where the Form 17 is from the seller and say, oh, it's uploaded. It's uploaded in the listing. Delivery has a legal terminology to it. Legal is has to be transferred from one party to another, either in person, by a letter that's registered, or by an email that is recorded, is delivery. Uploading something in a listing, it's interesting information, it's not delivery. What if something changed from when that form was filled out a year ago or 6 months ago, that the seller needs to update that Form 17 to make it accurate? And that's why in this law, it turns around very specifically, and it tells the seller that they shall, within 5 days, fill this form out after mutual and deliver it. So with this, I want to move into, again, transferring this over to what this looks like for Form 17 instructions. So the instructions pick up where the RCW leaves off. It starts off talking about it, but it says buyer has 3 days to rescind the purchase and sale agreement after the seller provides a completed, this is a huge word, completed Form 17 to the buyer. If seller fails to provide the form to the buyer as required, a completed form, the buyer retains the right to rescind the contract at any time prior to closing. Okay, buyer has 3 days to rescind the purchase and sale agreement after seller provides a completed Form 17 to the buyer. So there's a couple things that are sneaky going on here, because the loophole is the word completed. If they leave a box unchecked on a row, if they have a yes answer with an asterisk and then go to page 5 and write in a continued explanation as the instructions ask, then it's not complete. Technically, it's not complete. So now you have a technical flag that will allow a buyer to say, well, if it's incomplete, then anytime between now and closing, I can just fill out a Form 90A and give them notice I'm terminating the contract. That's very rarely ever disputed. What's disputed is what was left open and not answered significant enough that it warrants returning the earnest money to the buyer. Who keeps the earnest money? And that's why Form 50 has to be filled out, because the escrow officer will not release it unless there's clear direction from the buyer and the seller, which is a Form 50. Okay. So I'm going to get into these little
Well, Tom,
more.
on a Form 17, we use 51.
51 is not ever used with Form 17, ever.
Well, then I have the wrong.
Form 51 is a rescission agreement.
Right.
90A is a rescission notice.
We need to look at that, because I think that
I'm
there's.
going to have this here. I'm going to look at it. You see, there's a rescission. Form 51 has to be a rescission that is mutually agreed to by the buyer and the seller and the brokers for both of them to be able to rescind a contract, which many times is done when there's a flawed contract, when there's something like an illness hits and the buyer and seller agree that we don't want to go through with the sale and they'd like to rescind it. There's multiple different reasons, but when you get into these RCWs, the only way to recognize this one is through a unilateral notice from the buyer to kill the deal. They don't need to have a seller signature on it. That's why 90 days to 90. I'm losing my numbers. So 98.
Yeah.
That's why 98 is the correct one for Form 17. Okay.
I'll hold my comment.
Okay. I'm getting warmed up.
All right.
Let's see. Do not alter or amend this form. You can't. The only way to do it is Washington state law. Under the law, buyer may waive the right. And that's that little box we saw on item 12 on page 1 of the purchase and sale agreement. However, if any of the answers to the questions in the environmental section, Form 17 is a yes, the buyer must not waive the right to receive that section of the form. The seller must provide that, at least that section of the form to the buyer, even if the buyer waives his right to receive the balance of the form. So that's a sneaky little provision in there. We have to double check. If you want to waive, we need to look at the Form 17 anyway, just to make sure there's no yes boxes in the area for environmental. Additional information for the seller must complete this form and give it to the buyer within 5 days of mutual acceptance. And so even if it's uploaded, even if it's been downloaded and looked at, the thing about this form And let's go back to fiduciary responsibility. When you're selecting your forms or acting as an attorney, you're representing the buyer, you have a fiduciary responsibility. You're looking out for their rights. If you turn around and have them sign Form 17 before mutual and attach it to the contract, there's two things that are completely upside down with that. One of them is by statute, the law says this is not intended to be put into a purchase and sale agreement. And there's unintended consequences if you do, because provisions of the contract come into play that are not in play with an outside document. It doesn't need to have the rights for attorneys and different things in it. It's not ever to be a part of it. And so when you turn around and have that signed and attached to your purchase and sale agreement, one, that's against the statutes for doing that. But the other thing you're doing on that is you are not protecting the rights of your buyer to have an ability for them to get out of the contract if they choose to. We have several release valves to get it out. You can have your title report can be one, your inspection report can be one, but also Form 17 is another one. And if they come to you and say, something's happened, I need to get out of this deal, and they're and deal with somebody that's hard to communicate with and they're unreasonable and whatever, you can play the card on Form 17 if it's incomplete. Form of rescission, boom, and get them out of the deal. But if you have them sign that form before mutual and sign their rights away beforehand, then you're not looking after the interest of your buyer. You just sold the rights away because of sloppy management of the contract document. I have more information on this, and it's really something you really need to be confident in when you deal with brokers that don't understand and have read the law and don't understand it, because you will know it better than they do. And the buyer has the right to rescind, and they can do it in their sole discretion. And so they don't even have to have a reason for why they back out of that. Okay. Now I'm going to go to another manual. This is the manual for purchase and sale agreement. Okay. And the purchase and sale agreement, they actually talk about Form 17 and item 26. So I made this shorter. I just took out all the pages that weren't Form 26. Item 26. This is people very rarely read this, but this is insert each addendum and attachment in this space. You should identify the form number and the title, e.g. 22A finance addendum, 22B contingency addendum. So this is where you're on your contract form and you're listing all of the forms to compile your complete contract. Note, it is important to identify all addenda to ensure they will be incorporated by reference as a part of the agreement. This is the only place that identifies that there are contingencies such as financing and inspection. If you represent the seller, do not reference Form 17 or 17C seller disclosures form, because by referencing them, they may become part of the contract. Making Form 17 part of the contract has several unintended consequences, including making the attorney's fees provision apply. In addition, Form 17 specifically says it is not part of the contract. Referencing the form in the contract also confuses the issue. Okay. And I will tell you, if Marcia and I get back to the office and we have 10 offers in that need to be reviewed, I bet 8 of them will have a Form 17 stuck into the contract. It's not because you guys filled it out, it's because the other broker filled it out. So again, scouring and doing research on this stuff, you find things that unless you really sit down and go through the RCWs and go through all the instruction manuals and go through all the forms and underline them and highlight, you have these little buried treasure nuggets in there that you'd never typically run across. And that's kind of what we do here, is trying to make sure that we have a chance to talk about these things. So now I look at the actual Form 17. And this is where it's laid out exactly where we started from with the RCW. This is where it comes and where it's explained. So do not leave any spaces blank. This is instructions to the seller. So if they leave one blank, then it's incomplete. This is specified. The question clearly does not apply to the property, check NA. If the answer is yes, and has an asterisk, please explain on the attached sheets. Please refer to the line numbers of the question when they provide them your explanation. So this is how to fill out page 5, you put the line number down and where the yes answer was, and then have your seller put in the extra comment. They're supposed to be there. Notices to the buyer. You have 3 days. This is right out of the RCW. And it says following disclosure made by the seller or not representation of the real estate licensed party. So there's get out of jail free card for the buyer and seller brokers.
That line 20 is probably, it doesn't look, I'm sorry, 33 doesn't look important, but it's missed a lot. They're either there or they're not.
This is the area for where they put that in and put their comments in.
Lisa Boyle submitted a form 17 on a transaction. It was the most beautiful form 17. Realize that in compliance, that I see a form 17 no less than 3 times, the same form. It is really the broker's responsibility to make sure. And what I do when I get one back, first I check the signatures to make sure they initialed on the bottom of 1 through 4 and the bottom of page 6, and that they sign page 5. Then I go back and then I make sure there are no blank, I don't care what it says, but there are no blank lines. And then I go back and then I look specifically for the asterisks, the ones that say yes. Is there an explanation on it? And I got a first one the other day where they had whole sections marked out, and I asked the broker about it, and they went back to the listing broker and they said, well, it's new construction, it's not applicable. Or no, they didn't say that word. It doesn't pertain to it. So I said, tell them to go back to the instructions and where it says every line. And if it isn't, then just put a whole bunch of NAs there for that whole section. That's all. But if it's just X'd out,
It's not filled out correctly.
yeah.
That's why this is such being a Washington state law, it is absolutely literal in what you read in those sentences for what the compliance is to the law. And it's so hard to get across. This has nothing to do with real estate for us. Both of these forms, the K and the 17. So here's an offer we got from somebody, your name nameless. There's another thing that is interesting. This area is not actual part of the contract. It is a ledger for keeping a ledger of what addenda have been attached and they're incorporated into the contract itself. Adding and deducting from this can be done anytime during mutual. And when that's added or deleted on here for clarity, you don't need to have an initial. There's the one area in here you could change something and not have to initial it, have it mutually initialed by the buyer and the seller. I just want to point that out. See, then here's a FERPA form. Now, here's a tip, is if you'll notice, any addenda, the very first sentence binds it to the purchase and sale agreement. This form doesn't have that, so therefore it's not a contract document. It's just as simple as that to tell. If it doesn't say it's binding it to that doesn't belong in there, then it should be out. This should be removed. Here's 122J. The following is part of the purchase and sale agreement dated. See that line? That's a contract form. That belongs in the packet if that's going to be included in it. Now, the pamphlet and other things that go along are deliverables. They do not. They go under separate transmittal. Here's an inspection waiver. Very dangerous to waive on inspection waiver. Danger. Okay, Form 17. So then I finally get to the Form 17. This is also part of the purchase and sale agreement, which doesn't belong here. And I start going down and I highlight here. If I come down and I start looking at what's going on here, there's a yes answer with an asterisk. That's blank, blank, These are all blank, blank. These are all blank. And I just go, my goodness. And I come down through here and I get down to where we should have some things filled out. It's empty. If I come down here, this broker had their buyer sign it. And they waive. It's, they can't use it anymore. This before they had mutual. Again, these two forms have inherent risk in them that we really need to educate the buyer and the seller. Also, maybe the other broker on the other side from you, that we've got to pay special attention to the utilities so to make sure they're paid, but special attention, especially if you're a buyer broker, to protect your buyer's rights during that transaction. If they want to get out of this deal for any reason, you have that. They need to be educated on whether they sign this or not, or want to sign this or not. So I've had them want to sign it because they want to tell that seller that they're not backing out of this deal. They want it. They want to buy this house. We'll waive it. And so they'll sign both of those areas. And that's fine, but it was their choice, their decision. Educate them, let them make the decision.
So what do you mean by, say they sign it right after they go mutual, same day? What do you mean by they no longer have the right to use this?
Because they accepted it, and then per the Washington state law, they can rescind it within 3 days. But they haven't had mutual yet, so the 3 days is ticking.
Oh, I see what you're saying.
And as soon
Before
as
they go mutual.
And then if they sign mutual and it's 1 day later and the day 3 is up, then they have waived, automatically waived.
Mm.
Okay.
Yeah, and if the seller did not fill it out all the way, then you still can go back and ask them to fill it out more. And if they do that, yeah. And if they do that though, then you get the 3 days back.
That is part of the law. If they update that, they get another 3 days.
Yeah.
Yes.
Okay.
Okay. Okay. Now we're going to get into rescissions. Oh, I know what I was going to do first. I was going to, this is, the legal hotline has all kinds of fun things in it, but is how wishy-washy the answers can get. Instead of being clear, they make it more muddy. So in the Form 17 disclosures regarding the practice of verifying accuracy and completeness, my question is, what should a buyer agent do in case where the buyer is in receipt of the seller's disclosure incomplete and appears to be inaccurate? The buyer broker should educate the buyer in statutory rights. And this is what we were just talking about a second ago. And this is a good reference point. Assuming the buyer has not waived the buyer's rights under the Seller's Disclosure Act, which means they haven't signed it yet. Okay. Which will happen when buyers signs either the second or third buyer's signature lines on Form 17. The buyer who receives an incomplete seller's disclosure statement retains the right to terminate the PSA for up to 3 days following receipt of the completed form. The broker should educate buyer as to the right and give the buyer information necessary for the buyer to determine how to proceed. This is a situation that buyer may, 1, demand the seller's provisions of a completed form, terminate the PSA based on the seller's failure to provide a completed form, or 3, allow the transaction to move forward, knowing the buyer retains the right to terminate the transaction anytime prior to closing based on the seller's failure to provide the completed form. So you haven't told anybody anything yet. You're just educating your buyer, say, you have these rights under the contract. It's incomplete. You can either ask them to fill it out completely, you can terminate and get out of here, or you can hang on to this. And if things go forward with inspection, this and that and the other, all the way up until closing, we can fill out a rescission notice at any time. What would you like to do? And that's their decision. Now, by the way, buyers brokers should be aware that scrutiny regarding seller's full completion of the form can be tricky. The instructions on the form indicate the seller must answer every question. Assume seller disclosure connection to a public sewer main and then fails to answer the question related to an on-site sewage disposal septic system. will the court find that the buyer who received that form has an ongoing right to terminate the transaction based on seller's failure to answer all the questions, when the only unanswered question related to the system that the seller indicated does not exist on the seller's property? There's no way of knowing how any court will answer that question. Some courts will require strict compliance from the seller and allow the buyer's recovery of the earnest money. Other courts will find that the seller substantially performed the statutory requirements and refused to return the earnest money to the buyer. The broker's role is one of educating the buyer as to the issues, but the broker cannot advise the buyer on how to proceed. Buyer has to reach the buyer's own conclusions, and the broker must advise to seek legal counsel. So the thing is it might be incomplete, and I might be able to terminate that agreement, but there might be a discussion on Form 50 about whether the earnest money gets retained or not. And the only way to settle that, if it gets ugly, is with a judge. And this is where our real estate brokers need to get together and help protect their clients and each other and start talking about what's going on here, because if it ends up being an issue with that seller saying, no, I think I need to keep that earnest money, the first thing that happens is, before we talk to a lawyer, maybe you and I should talk about how we protect our clients, because if it's a $5,000 retainer, you can spend $5,000 on a lawyer, just in a couple of visits without doing anything. And then that's on both sides. So they can spend $10,000 arguing over $5,000 super fast. And is that the best thing for our clients? Is that the best thing we're going to advise them to do? You might want to help coach them a little bit and say maybe they should think about negotiating, maybe split the retainage, or try anything you can before you really say, okay, if that's the case, then your next step is to talk to an attorney. And that's where you don't know where it's going to go from there.
So Tom, if it's an escrow when this happens, and there's a dispute over the earnest money, whether it's verbal or in writing, the escrow is going to put a kibosh on it right there. They're going to stop everything, knowing there's a dispute. And if there's not an agreement on how to disperse the funds within a certain period of time, which I don't have the RCW to see what that is right now, but it's a certain period of time, then that money goes to gets interplayed into the courts. And if that happens, there's admin fees. There is the right for the escrow agent to retain fees in association with filing the claim.
Yeah.
But so you never know how much that would be. Right. So start thinking about what's all going to be subtracted, because in most cases, unless it's exorbitant earnest money, it's going to be gone by the time it's decided. It'll be eaten up by the courts. It'll be gone.
And
So it's always in the best interest I believe, to try to set to.
that's why we're trying to have more knowledge, more backing, have confidence that you understand the statutes and these forms better than who you're talking to, one. Then try and use your people skills to try and educate that other broker that the worst thing that could happen to our clients is have it be gobbled up with all the administrative fees and court fees and everything being deducted out of it because they talk to a lawyer. If we can't convince them to amicably do this now between us, right where we're at, it'll go someplace we can't get it back from, and the money will be gobbled up. But these are things that you don't find in classes and everything you study. This is real world ugly when things happen when you're administering a contract. And we have to know how we want to set things up, especially with the relationship with the broker on the other side of the deal, right from the very beginning. Try and get a good communication, working relationship with them. And also I try to use these hotline as my way of exchanging information with another broker, so that I don't come across as a smart aleck and insult them because they think they know something and I'm trying to teach them something they don't know. If I can send them, I say, I saw this hotline and I was looking at it, seems to apply to what we're doing right now. And if you look that over, why don't we talk first before we get back together again with their clients? And that way I didn't turn around and say, hey, stupid, read the damn contract. Instead I send them something and say, hey, look at that. I'm trying to nuance this in a way where I don't set them up to have a negative reaction for how I give something to them. And once you know a broker well enough, you kind of feel that out. But it's really important because this could go sideways quick, or we could have an amicable settlement. Both clients are happy, both like our brokers. If we do a deal again in the future. Okay.
A side note, for earnest money can never be kept more than 5% of the purchase price. So if you have a 750 to $1.5 million home and they put a couple $100,000 down, then their risk part of it for earnest money is never more than 5%. So if it did fall apart and then there was some that was going back to the seller, that's always good to keep in the back of your mind.
So this is Form 90A. The following is a part of the purchase and sale agreement. There's a contract document. Notice of rescission of agreement pursuant to RCW 64.06. 64.06 is Form 17. So this ties it right back to the statute, to the law. Check the applicable box. Buyer has reviewed the seller's disclosure statement, Form 17, 17C, or 17 commercial, whichever is applicable, and elects to rescind the agreement. Buyer hereby demands return of the earnest money, box number 1. Or seller has delivered a seller disclosure statement, Form 17, blah, blah, blah.
Has not.
Oh. Has not delivered the seller disclosure agreement, whichever is applicable. The buyer is required by RCW 64.6 hereby elects to rescind the agreement and demand return of the earnest money because he didn't provide it. Which, by the way, if the seller broker has it listed and it's up in their associated docs, you get mutual 5 days later, and they have not transmitted and delivered from the seller filled out to you to give to your buyer, then that 5 days is expired if that's what's in the contract. And so all of a sudden, checkbox 2 is in play.
So on that, say 3 weeks go down the road and you're out of your inspection, you have no more contingency backing, you have no financing, and they never sent you that. You could use that at any point in the transaction.
Yes, you can. Box number 2. That's because he never delivered it. It's about delivery. And associated documents is not delivered. There's no access to that by a buyer.
Right.
Those will only be accessed by a broker, the buyer broker or listed broker. And then the last box is seller has not delivered a completed seller disclosure statement to buyer as required by 64.6. Buyer hereby elects to rescind the agreement and demands return of the earnest money. So, and notice this is a notice. It's a contractual term that is the contract, which is the actual Form 17, and they are by legislature giving that buyer the right to terminate a purchase and sale agreement. It's not part of the contract, but it has the right to terminate. To do that with a notice, you only need one party signature.
That's why it's really important.
That's
not
the
to
difference
include it
between
with your
this.
offer.
And that is,
Tom, can I ask you another question on that?
yeah.
So what if after the time period of having that delivered, like say you're representing the buyer, let's say a couple weeks after you go mutual, the listing broker emails or text or whatever and says, hey, can I get the signed copy of the Form 17?
You just inform them that that has not been delivered.
Now, I lost you somewhere. Who you represent?
So if I'm representing the buyer,
Okay.
and the listing agent has put Form 17 on the listing, assuming that I was going to take it from the listing, and did not include it with the offer, and then a couple of weeks later, the listing agent's like, hey, can you send me over Form 17 signed?
It's really easy. One has not been delivered.
And what do you say? They say, okay, I'll send it to you, or it was on the,
If it's on the thing, it's not delivered.
If they say, I'll send it to you, you can say that it is out of compliance right now. And if they send you one at that particular time or an updated one, then your buyer has 3 days.
But if they didn't send it to you within the 5 days, technically, they have the length of the contract to
That's
terminate
correct.
anytime.
Yes, that is
So
correct.
if they, they send it, within those 3 days, buyer signs it, we send it back to the seller. And then day before closing, buyer gets cold feet, you would still back out because they didn't deliver it within the first initial 5 days,
Correct.
even if they signed off on it.
That's where it gets murky. Now you're gonna have to talk to an attorney.
You're getting into attorney territory
Right,
there.
now you have to have an interpretation. You and I can't do that. We can fill out forms and choose forms, but we can't interpret.
Can I ask a stupid question? If it's in command, so what you're saying is if it's in command and they've uploaded this stuff to command, which all agents can see,
Okay,
It's
so no,
not-
Northwest MLS.
or in the MLS, I'm sorry, in the
Yes, for the
MLS.
listing, uh-huh.
If they've uploaded all that in the MLS, that's not delivery in any manner,
That's
period.
correct.
Okay,
No, it's not.
It's
And-
called.
as I said, stupid question.
And this is our.
No, it's a great question.
Here's RCW 6406030, Washington State Statute law. Unless the buyer has that level, no later than 584. Otherwise, after mutual acceptance or a written agreement between the buyer and the seller for the purchase and sale of the residential real property, the seller shall deliver to the buyer a completed, signed, and dated real property transfer disclosure statement. That's right out of the law. Not the contract.
Yeah, I was just saying this, so it being available to the agent on the NMLS does not constitute any type of delivery at all.
Yeah.
That's what I'm
That's
saying.
correct.
Because
That is-
if what they're saying is that, oh, well, they're saying it's on there, why didn't I just pull it out? You know,
It's not delivered. Pull anything. You're supposed to deliver it.
so it has to be
You
emailed.
have to
or
deliver it to my buyer.
Mhm.
And the way to do that is you send it to me to give to my buyer. And it has to be done within 5 days of mutual, but it also needs to be filled out by the seller. I don't know what you loaded up there, how old it was. If you give me one within 5 days of mutual, I then can rely on that seller has looked it over, it's up to date, and it's recent, and it's good to go.
What if it's dated for like a month prior? When you get it, I mean,
That's all.
Sometimes that's the most updated version.
Yeah.
Sometimes they're 6 months old, but nothing's changed. Mhm. They have to be within 1 physical year of the mutual date.
okay.
Yeah.
Okay,
Yeah.
so-
But there's some real traps in this also. And as a real estate broker, if you represent a seller and this had something in it that was revealed and it wasn't in the Form 17 and the deal falls apart and then you relist it. If that seller doesn't go back and update this Form 17, they're liable for that. And if you are aware of it. That happened in Chelan. You know, there's a circle in Chelan. A brand new circle, everybody drives around.
Roundabout.
I don't know, is that what it is, a roundabout or? And that house got sold. And during inspection and feasibility, and they're going through, they found out that there's plans in the city to put this roundabout in. And so that buyer realized that where the right of way was going to be right up next to where the house is. And they killed the deal and got out of the deal. So they relisted it. Now with the knowledge that that's going to be going in, the next buyer came along and buy it. The Form 17 was not updated. They bought the house and then one day there's a surveyor outside putting stakes in the ground across their front lawn. They go, what are you guys doing? Oh, we're getting ready to rip this up. We're gonna put a roundabout circle here. They go, what? They sued everybody. They sued the real estate brokers. They sued the buyer or the seller. And then the lawyers just loaded up and went after where in place they could find money and they sued and won. That's where you have liability insurance, man, hope you have a good one. So the thing is that the broker being aware of it should have explained to that seller, this is something that's a material change to a property that should be disclosed to a future buyer. We need to put it on Form 17 and update it. They didn't do it. So as a broker, we got to pay attention to that kind of stuff. I mean, there's little tripwires in this thing because it's not a real estate contract. It's a state law. I keep coming back and hammering on that. But now when it sunk into me, I was going, this is an anomaly that we really need to be careful of. And there's not many of them out there, but attaching these things and incorporating them into the purchase and sale agreement, and all of a sudden lighten up that lawyers now have rights to get reimbursed inside of those things, and it's absolutely against what the statute says. What's that say as far as working to the standard of an attorney? We just blew that one right out of the water. Now, I had another one up here. That's the actual, where is it? Here's the rescission agreement. This is a Form 51. And there's all types of reasons why parties may choose mutually to rescind a deal. This is the form for that situation. They release each other. They decide how to disperse if there's the buyer gets any, the seller, the listing brokerage firms, any compensation from the earnest money for killing the deal after all the work that everybody's put in to make it happen. And compensation has to be signed by the listing broker, the seller, and the buyer broker, as well as the buyers and the seller. This is an amicable form for when you're trying to help provide a service for parties that want to get out of the deal. Usually, very different than the notice where only the buyer needs to sign it.
If I can go back to a Form 17, about a week and a half ago, I got a question. How long does a seller have to put a defect, especially one that they fixed? The tree fell on the roof and they repaired the roof. The septic system failed and they put in a new septic system or whatever. And so in talking with Russ about that, typically, as long as they own the property, they need to disclose that. If they sell it and the next owner didn't experience it, that's not a defect that they have to disclose. And so that was kind of a rule of thumb. I just thought you always had to, but then you'd have these Form 17s that say in 1978, I replaced the roof. In 1985, we did it again, kind of a thing.
But what if the seller knew about the previous defect? They can list it if they want to.
They're not required to.
That's right.
If it didn't happen, I didn't know that. I thought it was anything he knew.
Well, if you fix a defect within like your time frame, and it's no longer a defect, depending on how the questions worded, because some of them are like in the last 5 years. And so if like the roof was bad in the last 5 years, I don't think that's the question for the roof. I think that's like, is that maybe? Then like they would put yes, and then that's where you have that spot on the 5th page to elaborate and add any attached documents, system fixing it.
Yeah. Okay. The Form 90A is a notice form. Because I'm a recovering engineer and I get anal retention sometimes. I went back and found every notice form invented by Northwest MLS. And I sorted them and I found out these are the notice numbers on the right-hand side, and I kind of put them in numerical order. But then I decided if I'm trying to find one in a hurry, I sorted it also by topic, appraisals. And then I also sorted it by the actual contract form. So in this case, if it's a Form 17, I know that a Form 17, what does it say there? Rescission agreement goes back in time. Rescission agreement may be used when both buyer and seller agree to terminate a contract. A 90A, notice of rescission agreement pursuant to Form 17. So I probably should take that out of there because that's misleading. 17C is Form 51 manual, rescind. So if I come down through here, I try to start collecting them in a way that I could do a quick reference by contract form, by topic, or by what the actual notice form number is, to see if I can make sure that I get the right form for the job, depending on what's going on. I've distributed this several times over the last year and a half, and I keep updating it and finding little things to correct on it. If you don't have one and would like one, let me know, because I've been sending those out. You like to have one of those? Okay.
So we have to update the July 11th forms.
For the forms, for
Yes.
doing that.
And
Okay.
just make sure, yeah.
Okay. So I'll make sure you go. Okay, is there anything else? That's pretty much what I had for today. I want to go beat the heck out of those two forms. Those pet peeves. I see them showing up and weird things happening to them. That one on the utilities is so sloppy. People say, no power, garbage company, garbage company. That's like, that filled it out. It's even written sideways across it.
I don't know who that compliance broad is, but she sends it back.
She's touchy sometimes.
Only to you, Tom.
Okay.
So she's kind.
Now, if you start putting some Form 17B to your PSA, we're gonna let you know.
I think I said on one review, if you must return this. And they sent me back a little note and said, a little nice, but still snarky.
Another thing is we started way back when we started going through the contingent process for contingent sale. And we didn't complete that. And what's happened is the new forms got updated. And so I need to go back to all my materials and put the new forms in and then mark them all up and get them ready. But I thought it might be good to go back and just start that one fresh and go all the way through. Contingent sales, that's an area that has quicksand in it all over the place. I mean, it's like
Aren't you saying?
12 different forms, 12 different forms can be used during one of
Yes.
those.
Yeah,
Yes.
I think there would likely there'd be a lot of contingent, I would think.
Yeah, and it's something that it appears complicated, it appears confusing, but if you follow the logic on it and you get familiar with the forms, then there's a method to the madness. You can get comfortable with it and you can be confident on how to manage it. But I remember you had one of the times we started going through, you were working on one. There's a bunch of forms. Yeah. So I think I'm working on that. Is there any other topics anybody would really like to see us dive into? Or let's keep going with our favorites then.
Thank you, guys.
All right, well, thank you very much.
Thanks,
Yeah.
Thanks. Good to see you again.
Good to be seen.
But it's simple. I
Yes.
just the correct verbiage. I have a buyer who's wanting to change his name on the purchase sale receipt for closing. I just have to put it on the form for me.